Hello, everybody. Oh, he's already in here. I was gonna let you guys know that I sent Donald a message, when I was getting ready to go live, and I said, yes, I thought of you when I made the title. And, he informed me that he has had a stroke. So everybody, please pray for him. Eva. I have to give kitty treats. They have been begging. As you can see, a few tails. Just a few. Aw, Tiny and Snitch, you guys gonna get along for just 2 seconds while I get treats? Isn't that sweet? That's special and rare. Hi, how's it going? How you doing over there? Where's Earl? Earl, I'm tossing treats. Earl. Oh, there you are. Are you coming? Come on. Before Ava gets them all. You know the drill. Here, I'll even put some right there. You like them. Go get them. Go get them, Earl. Ava. Hi. Sorry. Donald kind of knocked me off my game there. Was not expecting that. Hey, buddy, I'm going live. Thought of you when I made the title. Hey, I had a stroke. What? He says he's a tough old bird and he'll be okay. His left side's getting stronger. So, we all hope for a very speedy recovery. Hey, while you're over there, tell him to redirect everybody over here when they're done. Hello, Wolf Lore Lover. Hello, Nana Laura. Hello, Charlie. Hello, Donald Westerdale. Please feel better. Hello, Edie Weedy Honey. I should say Edie Weedy Sweetie. April was shocked by the news and needed a minute. You are so sweet. Thank you. Hello, Eileen and Carlin. I got some good stuff for us today. I got some really good stuff. I really, 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 really hope Biggin does a redirect. That would be amazing. Because it's the perfect day for it. It's like over an hour and a half of content. Hello, Dark Zoomy. Our dear sweet Donald Westerdale had a stroke. His left side went numb. It is strengthening. He is getting better. So we all just need to pray for him. I love the optimism of this man. It's just a slight stroke. A stroke's a stroke, my dear. It doesn't matter how small it is. A stroke's a stroke. But we all hope you get better. Isn't he just adorable? He's a doll. He was so much fun. We had just such a blast. I can't even say it enough. We had so much fun, especially getting ready for that little stunt skit at the beginning. Take this stream to Cuba. I think Don enjoyed it too. Thanks, sweetie. I appreciate that. Hello, Penny. All right, guys, we are going to jump right into the enjoyment here. Double the pleasure, double the fun. We're going to start in Lake Forest Park. Where's my squishy? Where's my squishy man? After that, we're going to go to Michigan. We're going to stay there for a little bit. And then we're going to go to North Dakota for a little while. So we're kind of all over the map today.
All right, Mr. McGuire, I see that you've tried to come back in. If you could activate your audio and video. There you are. Now I can see you. Can you hit the button that will do the audio?
I'm here. There we are. I'm sorry, Your Honor. This is my second Zoom meeting in my life, I think. I apologize, but
that's no problem at all. All right, so you are here on case 250434829. This is a speeding in a school walk zone. And I see here that the violation occurred on November 10th of last year. And it was 11 miles over the 25-mile-per-hour speed limit. So this is a mitigation hearing. I'm willing to listen to whatever you would like me to consider today.
all right, may I?
Yes, go right ahead.
Hi, Your Honor. Good afternoon. I am 72 years old, have never seen a sign that says school walk zone in my life. It has to be admitted it's ambiguous, at least. I thought what it meant at 9:30 at night was that around the corner, I would see one of those yellow flashing light setups that when you would see the lights flashing when it was school time, that would mean that the school, speed limit would be 25 or 20, whatever. I see the photo that was enclosed in the citation was of the school sign with the flashing yellow lights, not flashing, and that says 20. But again, I've never in my life, in 72 years, driving since 16, have never seen a sign that said school walk zone. It means absolutely nothing to me, except that I would expect around the corner to see one of those flashing yellow light setups with the lights flashing if it was school hours. I've shown this to a bunch of people since this uh, date, November, whatever, and everyone said the same thing. They said it means nothing to them because it's so ambiguous and it's not a standard sign. It's not like any other sign anybody's ever seen in the United States of America. So I hope you, and I also looked it up and found that, well, the city of Lake Forest Park has made, as of the time I looked it up, or an earlier date, was over $14 million from this ambiguous sign.
Sounds pretty official if you ask me.
So I guess ambiguity pays in some places, but I didn't have a clue what that meant. And as I was in a rental car, I was playing with the defroster or something. It really didn't click to me what that meant. If you really wanted the speed limit to be 25 there, I don't know why there wouldn't be a sign that just said speed limit 25 miles an hour instead
Well,
of school.
there is speed limit signs that say 25 miles per hour. The monitoring in that area is because it's a designated school walk zone, which is identified in the RCW. So that is the authority for that photo enforcement. So I understand where you're coming from, but the posted speed limit is 25 miles per hour in that stretch of Lake Forest Park. You were going 36 miles per hour.
I was by myself on that road at 9:30 at night. There aren't a lot of places in the world, and I've lived all over the world, that 36 miles an hour would be considered anything other than safe and reasonable. I didn't understand the sign. The sign, I believe, is ambiguous. I think a lot of people, about $14 million worth of people, would agree that it's ambiguous. It's not clear what's going on there. That's the best I can tell you, Your Honor, that
I understand that you may not have understood what that referred to, but it is in the statute. The issue that I'm looking at is that it's a 25 miles per hour area and you were driving 36 miles per hour. No one is saying that it's reckless. It's a speeding violation. It was 11 over. So that's what I am considering here. I do see that it was a rental. Initially, maybe you're from Oregon or somewhere.
no, the car's from Oregon.
Okay.
But I was just saying, I was trying to defrost the windshield. It didn't click in my brain that this meant the speed limit where you are is 25. It meant that around the corner you'll have a school walk setup, which again at 9:33 at night doesn't raise any alarm bells for me.
Right.
So,
The alarm bells are simply that you follow the speed limit, right? That's when you see a speed limit sign that you have to follow, it's 25 miles per hour. If it had been flashing, you would have had to go lower down to 20, which is what the speed limit would be in a school speed zone in the entire state of Washington. So that.
How many knots is that, Your Honor? Maybe we just need to convert it for him.
That area, the speed limit's 25. I'm happy to mitigate the penalty for you, but I understand your explanation, but it doesn't negate the fact that there was a speeding violation. And
I wouldn't know what the speeding violation was, Your Honor, because the
it's
sign is
25 miles per hour.
It's so ambiguous that I wouldn't have had any idea. It's so ambiguous. I mean, again,
Well,
it's the
Mr.
only sign
McGuire,
of that type. It's
Mr. McGuire, the
Captain.
issue here, you may not have understood the school's walk zone or the photo enforcement aspect of this, but you very much have been driving since you were 16 years old, and you do know how to read a speed limit sign, and the sign in that area is for 25 miles per hour. So that was what you should have been driving, and you were 11 over. So we have a speeding violation, and there's no ambiguity there. So I'm happy to mitigate this for you. And I would reduce this ticket from the $145 to $90. So I will mitigate that for you.
Your Honor, I have to inform you, I'm also a supplemental security recipient. I've just been going through cancer treatment, spinal surgery, retinal surgery. It's been my year for medical stuff, so I have had no income, and I am a supplemental security recipient, which I believe has some effect on that.
Okay.
He's a supplemental security recipient who is also a captain in a neck brace. If he's had that many recent surgeries, I really doubt he's captaining a ship today while he's wearing his uniform in his car court office.
That is an extra form that you could have sent in to get that reduction. I will honor that today, but the expectation in the materials is that you will submit that in advance. So I will reduce this to the 50%. It'll be $72.50. And if you want to break that down into multiple payments, if that would be easier for you financially, happy to accommodate that as well.
Listen, Your Honor, with all due respect, this really looks to the outside world like a money grab with that one sign and $14 million in revenues to the city. I make a point never to drive through Lake Forest Park again, and I'll make a point never to spend a nickel on Lake Forest Park. I really think that's just a speed trap on it. And again,
Okay.
I've heard you be very kind to people here. Nothing personal, Your Honor, but it looks like a speed trap to me.
Okay, you've expressed your opinion on that. I will send the paperwork. Are you still living in Unit 225 in Seattle?
Yes.
Okay. We'll get that mailed out to you. Would you like us to include materials for you to be on a payment plan, or will you be able to pay in full by September 20th?
I'd like to see that option, please.
Okay, we'll include that in the materials for you. All right, thank you, Mr. McGuire.
It's Captain McGuire, but thank you.
Thank you, Dr. McGuire. I did not know.
Captain, ship's captain.
Oh, excellent. Okay, thank you.
Thank you, Your Honor.
Oh, how could I forget Arizona? Oh, Arizona.
Gila County Jail.
Hi there, Judge Garvin Payson. How are you?
Hey, we're so good. How are you?
All right, that's great. I was wondering if I could get an appearance with James Bannon. He's in custody there, and it'll be an arraignment, so it'll take a little while.
Alrighty.
All
Yes,
right.
Bannon.
So you want me to send an invite,
Yes, please.
or do you want to send it to me once you get him up?
Yeah, we will do that.
Okay, sounds good. I'll be waiting.
Okay, thank you, sir.
You bet.
Payson Courthouse, huh? Hello, Your Honor.
Hi there. How are you?
I am top of the world.
All right, sir. This is regarding case 2026 TR 209. If you would state your full name.
James T. Bannon III. I'm the good Bannon. It took me 9 years to get the other one in prison.
Okay. Want to confirm your address.
150 of the top attorneys in the United States with an 85% conviction rate against the Orange Buffoon.
All right, sir.
And
What we're here
they're the
for,
ones that you'll
what
get
we're-
a chance to meet
what-
real soon.
What we're here for is you failed to appear on a driving suspended, revoked, or canceled driver's license violation.
Yes, sir. I have been illegally detained by numerous police departments, and there are multiple lawsuits.
Okay. But you are James Bannon.
I am James Bannon, the good Bannon. Yes, sir.
Okay. And then, so there was a citation that was issued to you back on, I'll review it with you to maybe jostle your memory. That was issued to you on,
And by the way,
June-
the Miami Police Department is my latest client, and Mesa will be next.
June 29th of
Jared
2026.
Sheridan from Maricopa County. Go ahead, Your Honor.
No, so that was, the citation was issued to you on June 29th of 2026.
By who, sir?
The Payson, let me see if that's Payson Police or Gila County Sheriff's. Give me a moment.
Okay.
Gila County Sheriff's
That's fine,
Office.
I agree.
Okay, so they issued you a citation. You signed for a court date to appear on July 15th and failed to appear. That's why we're here. Okay.
Yeah, and again, I have been legally treated for months here in Gila County.
Okay, so what I'd like to do, with your permission, sir, since I have you by video, is to go ahead and take the arraignment now from you and take a plea from you. To be able to do that, I have to get you to agree to waive your personal appearance. Instead of scheduling another court date where you have to come back to court and stand in front of me, I can do it right here by video with your permission to waive your personal appearance.
Out of respect, no, Your Honor. I
Okay.
ask for protective custody of Jeremiah Brasowski, Chief of Staff, Pinell County Head Attorney, and I ask for a change of venue to Bradley Miller, who's already been informed.
Okay, sir. With that, since you're not going to waive your personal appearance, I'm going to hold you in custody on the violation for failure to appear with a $500 bond. It is bail bonds eligible, and I'll set your next court date, and we'll see you then. Unless you bond out, then we'll see you after you bond out on that court date.
Yeah, and I'm pulling Judge Cannon's bar license with the state of Arizona, and I advise your people not to break the law like they did for 72 days by refusing a phone call, refusing attorney, refusing bail bond, attacking me twice on video camera. This is getting deep, Your Honor.
Okay.
And we are talking about democracyforward.com. Do you know who they are?
Sir, I'm not going to answer your questions. I'm asking you questions. That's all I have. Have a good day.
Diligence, Your Honor.
Have a good day.
Next matter is Sally Sanders and Daryl McDowell, file 26-42444-GZ. Who do we have present for that matter, please? I do see Mr. McDowell. Ms. Sanders is trying to unmute herself. Mr. McDowell, if you could unmute yourself too, please.
Sorry about that.
No, you're good. I got no problem with that. I just want to make sure that I could hear you when you began to talk. Ms.
Sure.
Sanders, if you could unmute yourself, please.
Oh, finally. I'm unmuted.
All right, good. This appears to be a dispute over a car. Ms. Sanders, what is it that you want me to do and why?
They haven't made payment on car. It was rolled in their rent. They stopped working at all on Easter Sunday toward anything, rent or car, and you just evicted them with $6,900 some dollars they owe me. And so none of it went to car. He's damaged the car. Supposedly whoever he damaged the front end said that they'll repair it. I'd like to get that contact. But yes, I would like my car back since he's never paid for it and been driving it 6 months hard, beating it up.
Mr. McDowell?
Your Honor, I disagree with what Sally's saying. We also rent from her.
Yeah, I'll take a good look right here. What you are witnessing is a perfect specimen of a very broken man. You'll see.
And I have made more than we agreed on a $5,000 for that car, and she's received over $3,000 for the car. But there was issues with she's like, I don't know how to say it, like backpedaling, I guess, with when we moved in there, our utilities were included in the rent, and
I'm not here on the rent, I'm only here on the car.
I understand, Your Honor, but it all comes together. Between myself and my 4 kids and my wife have worked close to $11,000 worth of work for her.
9,000,
And,
and you
Okay.
overrated it.
Ms. Sanders, Ms.
Sorry.
Sanders, you
we're-
don't get to interrupt. Go ahead, sir.
But once it was time to, when all the hours got submitted, she initiated the rates for pay, and when it was time for the payments to get made, she started saying that, like the kids weren't worth, $2 an hour for this and just different things. And we tried to do mediation and I wasn't able to make it to the first meeting. And then I didn't even know that, we had a hearing on the 20th.
So wait, you rent from her. She sold you a car that she rolled the payments of the car into your rent. In lieu of rent and car payments, you were doing work for her to the tune of $11,000, I'm assuming in home repairs. And once you submitted to her the invoice of the work that you've completed, she started going through and nitpicking and readjusting the pay rates based on what she deemed was necessary or sufficient. Guys, I'm on his side.
Which I have a call into a lady named Ashley that I'm going to try to get that part figured out. But as far as the car, Your Honor, she's gotten over 3,000 of that money, and I have all proof on text messages and stuff. And I was going to ask for just even a couple days because to get proof of that, because once again, we're going through today, a couple hours ago, the electricity got shut off. This is again, I know it has nothing to do with the car, but I'm unable to get into my text messages or everything like that because I need a Wi-Fi connection, and I can't do it when the power's off.
Here's what I'm gonna do. I'm gonna be a very busy judge throughout the month of August. So the first court date that I have available for you to have a contested hearing on this is September the 21st. So I'm going to set aside an hour on September the 21st for you guys to have a hearing on all of this. So I'm giving you notice right now as to what needs to be done.
Judge, he has made no payment.
Ms. Sanders,
we attributed all of that payment.
Ms. Sanders, don't talk over me. I'm telling you right now that it doesn't matter what you say today, because the first time that I can hear both sides is on September the 21st. So whether you have a great point to make or not, it doesn't matter today. Okay? I will hear both of you, and I will hear all that you have to say on September the 21st. Okay, you'll get a notice in the mail as to what time that is. If you don't get a notice in the next 7 days, call the court and find out when it is, because I don't want to hear anybody say, I didn't know when it was supposed to be, because I'm telling you today when it's going to be and how to figure that out. So September the 21st for an hour, you'll both have an opportunity to tell me anything that you want to tell me. Bring everything with you. Anything that has anything to do with this car and how much was paid and how much was worked off and what the disputes are, have it with you on September the 21st.
Yes, sir.
Do either of you have any questions about that?
Judge?
No, Your Honor.
I attributed all of his hours already. Can the car be put in some kind of escrow where he's not allowed to drive for this much longer? He is beating my car up, has made no payments.
That's not true.
All I can do is hear it as soon as I can. And all I can tell you is my first date to hear it is on September the 21st. If there's any additional damage, take pictures of it and I'll deal with it on September the 21st. That's all I can do.
Are you going to be moved out on the 29th?
That's all for today. Thank you very much.
Are you going to be moved out on the 29th?
See, it's just nonstop, man.
Yeah. You take advantage of someone so hard, that's what happens.
Okay, guys. The fact that the judge had to yell at her to get her to stop talking over him, she's a control freak. She has zero interest in the car itself. It is just a tool of which she can use to hurt this guy. I'm convinced of it. Her personality just screams, I'm in charge, and if you don't think so, I'll make sure you know so.
No, you're up. You should be back on.
Mr. Sylvester, Ms. Lounsbury, can you hear the court?
I hear
Yes,
you.
sir.
All right, good. For some reason I was muted there for a minute. All right, this appears to be a dispute over a dog. I'm going to have each of you tell me what the issue is and how you want to settle it. So I'm going to start with Ms. Lounsbury, and then I'll go to Mr. Sylvester. So Ms. Lounsbury, what do you want to do and why?
I just want Mr. Sylvester to leave me and my dog Ziggy alone. I received Ziggy from him over a year ago. Ziggy's been in my care. I've been caring for him. The threats, because I wouldn't give him to give to somebody else because he was misleading that other person as he misled me about Ziggy not biting or getting along with all other animals. It started with a police call, then an animal control call, and now we're with you.
So when did you get Ziggy and what's your claim to own him?
I've had Ziggy for over a year. I actually sent in some screenshots off Facebook post that he put Ziggy up, trying to find him a good home. The post where Zach Sylvester acknowledged that I was Ziggy's new owner and how good I was doing with him and how happy we were together. Everything was fine until I told Zach to leave us alone.
When did you get
It-
Ziggy your household?
March of 2025.
All right, and how long have you had him in your home?
Since then, he's been with me throughout the whole time. I've let Zach take him for walks. He took him to his house a couple times, but his dog had tried to kill Ziggy prior to me getting him to rehome him, and he had attacked Ziggy since I had him in one of those visits. So I told him no more taking him to his house, only for walks, and he'd done that here and there. But he was trying to control things in my household, and I just don't want nothing to do with Zach anymore.
Is there a previous relationship between you and Mr. Sylvester?
No, sir.
So this is just about the dog?
Absolutely.
All right, Mr. Sylvester, what's your claim to the dog and why should I give him to you?
Okay, there's a couple misinformation things there. She did not have custody of him until June. I have medical documentation from the Little Traverse Bay Humane Society that I am his owner, and I have documentation from Animal Control that states I am his owner. We had an agreement, which I have saved in text. Originally, I went and rescued Ziggy from St. Charles. Yes, St. Charles, I believe is the name of the town. And he lived with me. I'm his owner. And yes, him and my one dog do not get along. And actually, my dog never attacked him. He has gotten out of her control at least 30 to 40 times, and I have many witnesses to that. And I've had to go get him on several occasions because she's unable to control Ziggy and hit her. And Ziggy actually ran up to my dog while I was walking my dogs. And yes, they do not get along. The only biting that had occurred was when I was separating two dogs from fighting, which is going to happen. I've had Ziggy around several other dogs. I have video documentation, pictures, and I have video and documentation of him being in my custody until June or July of last year. And I also have text proof stating that the agreement was, and that's what made it difficult, is because I did not want to lose being in Ziggy's life. My original agreement was with his original owner that I rescued him from, that I would stay in his life, and I was actually going to keep him. But because him and my one dog do not get along, I was trying to find somebody that would agree to let me keep responsibility and ownership over him, but stay with them. I've only been to Kelly's house maybe 8 to 10 times since she's had him. I've had to buy Ziggy dog food on a couple occasions. I've bought him a couple big bags of dog food. She has no income to take care of him. I have several text messages of her asking me to rehome him because she cannot take care of him. She cannot walk him or do anything. And then she even screamed and cussed at me. I have never once gotten loud with her. She even showed up on my property 2 days ago because he got out again. He has been out at least twice just in the last 2 weeks because she cannot keep him under control. And I found a better home suitable for him. And like I said, I do have documentation from both Animal Control and Little Traverse Bay Humane Society stating that I am his owner. And I have text messages to her agreeing that I will stay his legal owner and have responsibility over him. And there has been multiple times where she asked me to take him and find him a new home. And then she'd come back and forth saying, no, I think I can take him. I think I can keep him. And this last time, a few weeks ago, she started screaming and yelling at me and swearing at me, telling me that I have to take him. He needs a new home. And on the day I went to go pick him up to take him to a new home, she flipped out on me, started yelling at me and cussing at me, and then told me I would never have to see this dog again and started saying a bunch of things. So yes, I had Animal Control do a welfare check on him. And the only other time the police showed up was to serve her court paperwork. I've never stepped foot on her property without her texting me first. And yeah, and I haven't even texted her or called her in weeks. So I don't know where the whole leave me alone thing has came from, because I have multiple text messages where I asked her to leave me alone. And she kept texting me, yelling at me, swearing at me, and telling me, how does it feel? How does it feel? Da 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 da. A bunch of drama. And so for Ziggy's well-being, I have a good home set up for him, and I need to get him back into my custody so we can do that. Because, like I said, she has no income. She is losing the place she's living in, and has admitted on multiple occasions that she cannot take care of him, has no means for him, and cannot feed him or do anything that he needs.
All right, Mr. Sylvester, it sounds to me like you're acting like Animal Control. Why is that?
I'm not trying to act like Animal Control. Like I said, I'm the one that originally rescued him. Dogs are my life. I actually own Zach's Canine Companions. And I'm not trying to control anything. I've not tried to dictate anything that she does. I'm just looking out for the dog.
Did you give her the dog? Did you give her the dog?
Yes. Well, under the agreement that I would stay responsible for him in any of his needs. And if she is unable to take care of him, that he would come back to me. And I even have text messages of her admitting that.
Where is that agreement?
In text messages. I can probably email them to myself and email them to you if you have an email address, or if there's a way for me to get that documentation to you.
Why would you not have that available today? You know that this is the court hearing for that. Why would you not have it available?
I guess I didn't get all the text messages. I do have the documentation from Animal Control that states I'm his owner with me. And I have screenshots from Little Traverse Bay Humane Society of all the medical documentation.
So what have you got from Animal Control that says that you're the owner?
I got Oxiola County Animal Control right here, with a picture of Ziggy, and it has all the description of him, and it says right at the bottom, owner Zach Sylvester.
What's the date on that?
October of 2024, because I had him that since.
So that was before you gave it to Miss Lounsbury, right?
Yes.
All right, so that doesn't prove anything. So when did you give Ziggy to Ms. Lounsbury?
June of 2025.
So what gives you the right to take Ziggy back after June of 25?
She has asked me to take him back on several occasions, and then would backtrack and say, no, I think I can.
Let me stop you right there. Did you take Ziggy back then? When she asked you to? Did you?
I started to find him another home, and then she would tell me, no, never mind.
Well, here's my question. Was she asking you to take Ziggy back because she was tired of Ziggy? Or was she tired of you and thought that that was the only way to get rid of you? Just because you buy a dog a couple of bags of food, it doesn't mean that you own the dog or are providing all of its needs. If that were the case, Joey Bag of Donuts and Jerry would own Ava and have just as much claim to her as I do. If you bought the dog food, good. You helped the dog. But you don't get to give a dog to a new owner, a new home, where that dog is forming just as much of a bond as the human is, and then rip it back away. Like, you don't get to play like that.
Okay, so she still had the dog, right?
Yes, sir.
So she then said, okay, forget about it. So what gives you the right at that point to take the dog?
Well, this last time she screamed at me, told me I have to take him, that she has no way to take care of him, no means to take care of him. This is BS and all this stuff.
So
I've
did you take
never
the dog
cursed at
that
her.
day? So did you take the
Not
dog
that day, no.
So
No,
what gives
because
you
I
the right-
asked her. Sorry.
What gives you the right to then take the dog at a later date?
We had set up an agreement for me to find him a home, and then the day I was to show up and pick him up, because we set an agreed date for me to pick him up, she went off the rails on me. And I have all the text proof I can.
So do you have the dog now?
No, sir.
Why should I give you the dog?
I have plenty of witnesses, and for the dog's best interest, he would be better with somebody that can take care of him.
This is not a child where I look at the best interests of the dog. What legal right do you have to have the dog back after you gave it away?
I guess just the agreements we have and documentation that I've been the one responsible financially for him through this.
You realize this is why we have contracts, right?
I should have had her sign something. I agree, and I admit that I messed that up by not having her sign documentation in the very beginning.
All right. Ms. Lounsbury, why do you keep calling this man?
No, I'm not calling him. I blocked Mr. Sylvester weeks
And
ago.
why is he talking about you cussing him out?
I only cussed him out when he told me I had to give him this dog or he was bringing the police to my house and making me give him. Zach has no right. I couldn't have said it better than you did, Your Honor. He thinks he's animal control, like he's God. This is my dog. He's been a service dog to me. Zach's.
Ms. Lounsbury, that's not what I asked. Why don't you have a contract with this man about this dog?
I don't understand why I would. I got him off a free post on Facebook.
You're cussing out a guy because you don't have a contract that says it's your dog. Do you have any documentation at all that says that this is your dog?
Yes, his own words saying
That's
that.
that's his words are nothing. How are you going to prove it's your dog?
The fact that I've had him, Your Honor, and I've cared for him over a year.
Great, but how are you going to prove that to somebody who's looking at this that doesn't know either one of you? How do you prove that other than you just tell me you've had the dog?
Have you taken the dog to the vet in the last year? That would be an important piece of the custody puzzle.
Do you have any documentation?
I
Have you
have
taken it to the
pictures.
vet? Do you have anything?
I have photos. I have the conversations that I actually sent to the courthouse so that you could view them prior to today.
So you got nothing. You got nothing legal. That's what I'm telling you both. You're acting like you get to do stuff like this all the time. And how is a
Your
judge
Honor, I had
supposed
just
to
put my dog down.
Stop.
Okay.
What I'm telling you is both of you are making fools of yourselves because you've got no contract about a dog. You don't just do this kind of stuff. A dog is if it's going to be this important that you're going to go to court over it, it's important enough to have a contract. It's important enough to take the dog to the vet. It's important enough to do things the correct way. Mr. Sylvester, you've got absolutely no claim on the dog anymore. It's Ms. Lounsbury's dog. Ms. Lounsbury, get yourself over to the vet. Start making a record that somebody in the future can use to assist you, and the two of you leave each other alone.
Yes, Your Honor. Thank
End
you
of
for
the
your
case.
time.
That's all for today.
Thank you, Your Honor.
Am I allowed to log out?
You are, sir. Go right ahead. All right, we have two matters involving the next parties. This is Tina Mix and Alicia Courtier. It's file 26-42285-GC. And then we also have 26-42144-GC. Who do we have present for that matter, please?
Alicia Courtier.
All right, we have Tina Mix present. She's here.
Yeah.
Tina Mix, would you put on your video, please, so I can see you?
There we go, sir. I was trying. Sorry about that.
All right. I have received a large volume of documents, it appears, from both sides in these cases. Have the sides been through mediation yet?
Yes.
We attempted, yes, Your Honor.
What did you do at mediation?
Well, Your Honor, I got sworn at and told that I wasn't going to get paid a dime. And nothing was settled. Ms. Courtier continued to speak over me, so I couldn't even talk. Nothing, absolutely nothing was resolved, Your Honor, because there was only one side of communication, and that was hers.
Ms. Courtier, is that true?
That is untrue, Your Honor.
Yeah, okay.
Well, tell me why I shouldn't send you both back to mediation now that all of this discovery information is available.
Your Honor, the
Your Honor,
discovery
I have
that you're
attempted-
looking at,
Go ahead, Ms. Courtier.
the discovery that you're looking at, the 3-ring binders, those belong to me. That is my discovery. The plaintiff has not provided any adequate discovery, only approximately 8 handwritten statements. She has not provided itemized receipts. She did not answer interrogatories. She has not provided witness lists. And each handwritten statement changes her claim and interest rates. I don't know what I'm defending, Your Honor. I don't know what we're mediating.
So Ms. Mix, have you answered all of her requests for interrogatories and all those statements?
Yes, sir. I did the best that I could. The credit card statements, I even broke down A, B, C, D, all the way through everything that was charged all the way through R and explained what each one of them were. I have pictures to document that she was with me on those days and this actually occurred. I have documents proving that she agreed to pay me for the amount of money that was split between the two of us after the vacation. I have submitted documents proving her erratic behavior and why I requested civil standbys. Ms. Courtier
Okay,
has
hang on. Here's the deal. You two went on vacation together, right?
Yes, sir.
Yes, sir.
Then put all that stuff back in the bottle. I don't want to have this contract issue. That's what this is. This is a contract. Does somebody owe somebody else some money? It's not about how you like or don't dislike how they talk to you or how they don't talk to you. This is a business transaction. It doesn't matter whether you like each other or not. You went on vacation together. So I'm going to assume that if you're good enough friends to go on vacation together, you're good enough friends to figure out all of this mess. You're not going to dump all of this on me to sort through 6 months or a year or 2 years of your lives.
But feelings, Your Honor. They had hurt feelings.
Without the two of you doing the hard, dirty work of figuring it out. So you're going back to mediation. I don't want to hear anything about she wouldn't talk to me, or she said this, or she said that. This is a business transaction. Treat it as such. Somebody either does or doesn't owe somebody else some money. If you guys are going to be free and loose with how you keep track of your records, then you're going to have to figure it out when the time comes to tally up the bill. Just like I told the other people with the dog, if you're going to make these kind of verbal agreements, then you're stuck with each other trying to figure out how to resolve it. I am not going to be stuck in the middle waiting through all of this because you guys won't take the time to talk to each other about how to resolve it. You're both grown adult women. I have no doubt in my mind that if you wanted to, you could figure this out. So I'm sending you both back to mediation, and I'd better hear that you wanted to figure this out. Have I made myself clear?
Yes, Your Honor.
Yes,
May
Your
I
Honor.
say something?
Is it going to be helpful?
Well, we have a scheduled
Hang on,
hearing on
Miss
August 3rd.
Courtier. Miss Courtier, hang on. Is it going to be helpful?
I believe so.
Then you may go ahead. Thank you.
We
Go
have a
ahead.
hearing scheduled for a motion to compel on August 3rd.
So I will do a mediation referral that is after that date, so that you may decide at that date whether or not you can get the information that you wish. In the meantime, Ms. Mix, if she is saying that she didn't get something, you need to do your best to make sure that she's already gotten it before the August 3rd date comes around. Is that clear?
Yes, sir. I don't understand what the motion to compel is.
It's a motion to make you do what you've already been ordered to do, which is to provide certain documents or certain information. She has apparently, and again, I don't have the motion in front of me, so I'm not going to dig it out. She has apparently asked you to provide her with some specific information. So she's now asking, at least on August the 3rd, we'll be asking the court to say, you have to provide this because she's already asked for it. So what I'm asking you to do, Ms. Mix, is go back over all of the stuff that you know that she's asked for and make sure that you have already provided it, because that's what we're going to go through on August the 3rd. And then I'm going to send you both to mediation to try to figure out all of this stuff. And the more organized both of you are, the easier it will be for you to resolve it. Does that make sense?
Yes, sir.
Yes, Your Honor.
All right.
Even if do I need to duplicate the documents if they were already submitted?
You
Just
don't
make
need to
another copy?
duplicate anything. You just need to give her what she's asked for if you haven't already done so.
Your Honor, can I tell you what I was asking for?
Yep.
I was asking for a clear, concise claim. Her amounts have changed, her interest rates have changed, how she came up with.
Don't tell me long version. Tell
The
me
total
short
that
version.
she came up with, how a clear breakdown of that, the total amount that she's asking for. I asked for itemized receipts that would describe which was her amounts, which is my amounts. She gives a lot of amounts, but never clearly says this is what she owed, how much she owes. This is what it was for. She just, again, her amounts have changed. They've gone from 7,000 to 10,000 to 103,000. Now we're at 2,500, but she never gives a clear, concise breakdown of how she got those totals. She doesn't provide itemized receipts. She doesn't provide a written agreement.
Okay, Ms. Courtier?
I don't know what I'm defending, Your Honor.
Ms. Courtier? 10 words would have sufficed.
Sorry.
It's all right. You want to know, in reality, the fastest way to resolve this matter? It's for the two of you to walk into the same room with the idea that we're going to try to settle it. And you can do that today. The two of you can agree to get together and try to resolve this. That's what mediation is for, but you can do that today. Nothing is stopping either one of you. If you want to fight about it, the court will allow you at some point in the future to fight about it, but I am not going to be doing the fighting for you. I am not going to wade through all of this mess. The two of you are going to do it. You created it, both of you. Both of you are going to resolve it. So if you really want to resolve this matter, pick a day, bring all of your records, sit down for however long it takes to resolve it, and resolve it. Instead of being hurt and angry about things, simply say, we have a business transaction. It needs to be taken care of. Let's get it done. I'd be telling the two of you, if you were two banks, to do the exact same thing. So get rid of your personality issues. If you went on vacation together, this is part of that process. Clean up the mess. I'll see you on August 3rd.
Thank you.
Thank you, Your Honor.
Just one moment.
Yes, sir.
All right. So turn the record on. There we go. This is file 2013-1083 DS. It is Destiny Wood versus Nathan Ivy, and we're here on an objection to the referee's recommended order. So let's take a peek at the referee finding here a moment. All right, so there was a request to transfer the matter to Kalamazoo and a request to change parenting time. And the proposed order, let me find where it's indicates that there, with respect to parenting time, there's no change in circumstances justifying a modification of parenting time. The transfer stuff is, that isn't even within the court's jurisdiction typically. If you've got a contiguous county, you're not supposed to transfer. If the county lines touch, you're not supposed to do it. Okay, let's see. Here's your objection. Was filed by Ms. Wood. I'm objecting the referee recommendation order because my motion for a change in parent time is based on no change in circumstance. The referee did not explain what circumstance were considered or give me the chance to tell at the time my original order, I did not have stable housing, reliable transportation, or income. Since then, my circumstances have changed. I now have long-term housing, a reliable vehicle, steady income. These changes have improved my ability to meet my children's needs, stability, and participate in their upbringing. I respectfully request a hearing. All right, so today is usually a day where I just look to see if you've got everything in order. So I see what you're saying there. Boy, it sure would be nice if we could transfer it, because everybody lives up there. Let's see. Let's look at the referee's notes. This says for parenting time, it says mom says she's had no contact with the kids in 6 months. Kids are sad without parenting time. Dad says dad's preventing parenting time, wants every other weekend, major holidays, and birthdays overnight.
Yes, Your Honor. My kids are seeing for direct days or times.
Not happening.
Well, let me ask you this. Did you not tell, so you're not getting any parenting time right now, Ms. Wood?
Oh, sir, I haven't even seen my kids talk.
No.
All right, and so why, and you're telling me you told you told the referee all these different things that you put in the objection?
I did, Your Honor. I did not state, he didn't have the chance to tell him my change in circumstance. That was the only thing I was not able to even state. He just said, there's no change in circumstances. And I said, excuse me, sir. And he said, well, this is my turn to talk. And he did not give me a chance to speak.
Nice.
So what did he give you a chance beforehand and you didn't say any of those other things?
At the beginning of the hearing, he did state that I want the court to know anything, but I wasn't aware to say it right then. No chance to.
Let me ask you a question. Mr. Ivy, I see you shaking your head saying no. What's the current order say? Does it say she gets no time?
The current order stipulates her doing drug test, which she did not comply with the very first year.
I have evidence on all that. I did, and I.
No, you
well,
didn't.
Hold on. I want to hear what he has to say.
And pertaining to her saying that I'm keeping my kids from her, I'm absolutely not. She used to call all the time. She used to call unannounced. She used to show up unannounced, and all she did was cry to them babies. So after for so long, they just decided when she did call, I asked them, do you want to talk to mom? They said no, because all she does is cry to me, Dad. That's exactly what they said, Your Honor. I don't keep my kids from her. And she used to show up unannounced. She used to have my kids dig through her trunk, through clothes, and all kinds of unhealthy things, right? So when she would cry to them kids, that's emotional abuse, making them feel like they're the ones, the reason why mom isn't around.
So let me tell you what I see here. This says, and maybe I need to check with Mr. Robert. I'm looking at an order dated 12/14/23.
Mm-hmm.
And in this order, it says, mom's parenting time is per terms in 23-712 NA. So that would have been a neglect case. Once that case is dismissed, parenting time shall be reasonable as agreed by the parties, but if no agreement, the St. Joseph County Friend of the Court parenting time policy applies, which means unless this order changed, her parenting time is supposed to be every other weekend. How old are the children again? Help me with that.
12 and 14. But what if they don't want to?
Well, you don't put that in the kids' hands.
Well, they're 12 and 14, Your Honor. They have their own feelings. And what
but they don't get to decide.
I know, but did you read the paperwork on what happened to my daughter while she was in her mom's custody?
No, I did not, because I didn't.
My daughter was molested being in her mom's custody, Your Honor. My daughter does not want anything to do with that right now. And both of my kids I had to pay for counseling for a year. The things that my kids told the counselor, and I can get that information as well. It's not good.
Well, let me ask you this. What if you had something that permitted some supervised time for a while?
Well, yeah, we had that in the very beginning. And she got loud and got disrespectful with the person who was the supervisor. And she failed.
Now, was that in when you had the other case going on, the NA?
Yes, sir.
He's talking to me.
No, that had nothing to do with that, though. Whole different scenario.
So here's what needs to right now. She has a court order that says she's supposed to have this parenting time. If you don't think,
not every other weekend. Hey,
that's their policy.
My daughter and them until I know the environment. My kids will not stay the night over there. They will not.
Don't give me a chance, Nathan.
They will not.
talk to them. They're terrified of
Okay,
They
hold
will not.
up. We
You don't
can't
even
have.
know.
Okay, hold up. Is the NA case dismissed?
Yes, sir.
Okay, so if that case is dismissed, then the order that I just referred to is the one that's in place. So it sounds like, Mr. Ivy, you probably would want to file a motion to modify that order, to change it. Because right now there's an order in place. So I'm gonna have to check with the, well, let me see what this.
So basically my daughter's gonna have to deal with what happened to her and deal with all that.
Hold up. Let me.
Longer. Everybody safe. He was in jail for a year, and he should have got longer.
Okay. Detective even
Hold
called me.
on.
My daughter told me all about that. Detective even called me, sir. I even have the information about that too.
No, your daughter will not have to go through all of that if you do the right thing and file the necessary motions to amend the parenting time, to modify it. Right now there's a court order, sir. That doesn't change just because you don't like something or something happens. You have to go through the process.
He was charged. He was charged for that.
They dropped the charges. Why don't you look it up?
No. He was charged. It don't matter. He still did it. He still did it. He
You weren't.
still did it.
You asked.
He still touched and groped my daughter.
Yeah, he deserves to be dead. Guess what?
Yup.
I'm sorry, Your Honor.
That's my job, is to protect my kids, and that's what I'm gonna do.
Mine too.
Regardless. Watch. See.
All right, so.
Supervised visitations, Your Honor. That's it. There's no staying over. There's no staying the night over there. There's no picking them up from school. Them kids missed 2 years of school, Your Honor.
What?
2 years.
Mr. Ivy.
Yes, Your Honor.
You need to file the motion, okay? From what you're saying, it sounds like you want to, and that would get things back there to talk about some of these other things. So if you contact a friend of the court, and I'm going to, this isn't looking for a change. She's just asking for enforcement, and you're going to want to file something that says, I don't think enforcement is appropriate because of whatever you said.
I mean, it's in the paperwork. It's right there. It's all in the paperwork.
Yeah, but you didn't file an answer.
I didn't know I had to.
Well, you don't, but if you want to get things the way that you're telling me, you'll listen to what I'm saying. There's a motion regarding parenting time that you could file.
Okay.
And you could say, this is why it needs to be different. I'm going to talk to he didn't answer her question. I'm going to send this back because the question, it appears to me it was never answered. She's not asking for a change. She's asking for enforcement of a particular order.
Correct.
And so
I was right there the whole time, Your Honor. She wouldn't even turn on her camera. And after she got denied parenting time in March, she sent me hateful messages. On top of that, absolutely not.
Contact all my messages.
Yeah, I got the messages too. You said I hate you. Soon as you lost, you said I hate you. Sending me all these nasty, disgusting messages. Nope.
Your mother's
right.
It don't matter. It don't matter.
All right. I'm gonna see what I can figure out about getting you back down there. Mr. Ivy, you need to file your motion to suspend parenting time.
Okay, so
She is not.
Okay.
She has not, the answer that was given to her, I don't believe was that what she was asking for. So I'll check this out further and see what I need to do, but you'll probably have a chance to file the motion you want to. And then if there's a different answer given, then you can object again. So, you know, honestly, let me tell you what happens with a lot of these, where these kinds of things happen. Can you hear me, Mr. Ivy?
Yes, sir.
Are your kids still in counseling?
No, they're not.
Okay, a lot of times what happens with this kind of thing is if a child's still in counseling, the counselor kind of helps and talks with the parent that is, you know, in the spot that Ms. Wood's in, and the counselor kind of tries to bridge the gap. It doesn't mean things get back to how they used to be, but sometimes they get back to where a child can do FaceTime with someone and maybe do some visits at McDonald's or something. So, you know, because there's a big difference between just ripping the Band-Aid off and going right back to the situation that you say you're concerned about. Doesn't have to be right there. It can be something intermediate where there's protections in place. So, I mean, you can't get too injured on a video call.
Exactly.
There's not a whole lot of risk involved with that.
Right. Now, and I would be okay with that too.
Yeah. All right. I'm gonna see what I can figure out about why your question wasn't answered, Ms. Wood, because the question that's answered is on custody or on your parenting time, and that's not what you were asking for. He did say, you know, you requested the transfer, and there's, you know, there's no authority for the transfer. We can't do that by court rule because it's an adjacent county. But let me look into this and you'll receive something in the mail.
Okay.
All right. All right.
My name is Nick Thornton. I'm a district court judge for the Southeast Judicial District, which includes Barnes County. Matter on the court's docket is State of North Dakota versus Michael Stephen Ryan, 02-2012, CR 295. Present in court for the state, Attorney Trent Jackson. Present by reliable electronic means without counsel, Michael Ryan. Mr. Ryan, can you hear and see me okay?
Yes, Your Honor.
All right, thank you. There was another person that had called in by telephone and apparently had their microphone too close or something because we had a bunch of feedback and echoing. That person is disconnected. That was not you, was it?
No, sir. I was my counselor. It might have been her radio that echoed. The CO3 who conducts she allows us to have these meetings.
All right, so when you said counselor.
Yes, sir.
I'm a case manager.
Case manager, counselor.
Oh, okay. So when you say counselor, sometimes that means attorney, and I want to make clear that's not your attorney. That was simply a case manager in the facility in which you're being held.
Correct, Your Honor.
All right. So Mr. Ryan appears without counsel.
Correct.
If that case manager wants to connect again, that's fine. And if she wants to listen along, she can. But she would need to probably disconnect her audio or mute the telephone if that's how she's doing it. So there would not be that feedback or reverb.
The phone is disconnected, Your Honor. Thank you.
All right, thank you. All right, so again, my name is Nick Thornton. I'm a district court judge for the Southeast Judicial District. We are in Barnes County's large courtroom. The door is unlocked and open. The building is unlocked and open. We're live streaming today's event on the Southeast Judicial District's live stream YouTube channel. As such, these are open and public proceedings. The matter before the court right now is a motion hearing. In this case, an information was filed back on July 23, 2012. So we're talking about over a decade ago. Record index 1. The defendant was not found. A summons was issued. The defendant was not found, and so the sheriff indicated that he was unable to find the defendant. Ultimately, a warrant for the defendant's arrest was issued on August 23, 2012. On April 21, 2026, the defendant filed a pro se motion to quash warrant, record index 8. The state did not respond to that motion, and it looks like it might not have been served on the state. The court issued its order on the defendant's motion to quash or in the alternative to modify the sentence, record index 9. That document was served by the court on Mr. Ryan and on Ms. Duffy, the state's attorney. Thereafter, about a month later, on June 1, 2026, Mr. Ryan filed a motion to quash the warrant, complaints, citations for violation of the right to a speedy trial, record index 11, together with Exhibit 1, which is letters and certificates Mr. Ryan has earned in the meantime. The state filed its response to the defendant's motion to quash, record index 13, on June 10, 2026. And thereafter, the court set today's hearing. Mr. Jackson, did I get all of that procedural history correct?
Correct, Your Honor.
Mr. Ryan, did I get that procedural history correct?
Correct, Your Honor.
All right. So, Mr. Ryan, it's your motion, so that means that you carry the burden of proof to raise the issue sufficient to shift the burden to the state to disprove the constitutional violation. Do you have any opening statement to give to the court before we move forward?
At this time, Your Honor, my objective is to resolve the matter. I'm not disputing the facts.
So they resolve the matter. What do you mean by that, sir?
Well, from 14 years, 15 years now, sir, and I'm not even sure of all the details. So I have nothing to dispute.
So are you saying you intend to plead guilty and appear on the warrant?
No, sir. I'm incarcerated until May of 27, and my intention is not to return to North Dakota.
I understand that, sir. But what I'm asking you is there's a couple of ways that we can move forward here.
Okay.
Option 1, we can proceed with your motion to dismiss because the state has violated your right to a speedy trial. That's what you moved the court to do.
Correct.
The other option you have is to say, I'm not going to contest the speedy trial. Instead, I want to plead guilty to the offense and resolve the matter. And so when you said, I want to resolve the matter and there's nothing to contest, I was unclear which option you're choosing.
Yes. Rather not have any more guilty pleas going on, but I would like to resolve the matter. So if there's a way to go about that today, I'd sure like to do that.
I'm going to treat your response as a request to move forward on the motion to dismiss.
Correct.
So, Mr. Ryan, do you have any other opening statement that you'd like to present concerning your speedy trial rights?
No, Your Honor.
Mr. Jackson, do you have any opening statement that you would like to present on the speedy trial issue?
I'd waive opening statement, Your Honor.
Mr. Ryan, I'm going to have you raise your right hand. Sir, for the testimony you're about to give, do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
You can lower your hand. Just for the record, please state and spell your full name for me.
Michael Stephen Ryan, MICHAELSTEVENRYAN.
Mr. Ryan, what is your birthday?
June 23rd, 1978.
Mr. Ryan, I have some questions for you, and then I'm going to give you an opportunity to give me a narrative statement. What I mean by that, sir, is you can just tell me what you want me to know in terms of evidence in sort of a story form. Ordinarily, if you had an attorney, the attorney would ask you questions and you'd have to answer those questions. And then the state would have an opportunity to ask you questions under oath as well. But ordinarily, it would be question and answer form. I'm going to give you an opportunity, because you don't have a lawyer with you, to simply tell me what your side or what you want me to know. And then the state will have an opportunity to ask you some questions on that issue for the motion purpose. Okay?
Yes,
You
sir.
understand, sir? All right. And because of that, we're not going to delve into the facts of the offense, Mr. Jackson, you understand?
Yes, Your Honor.
All right. It's simply going to be to address the speedy trial issue. Mr. Ryan, where are you physically located at now?
I am in Douglas, Arizona, in custody of the Department of Corrections.
The Department of Corrections in the state of Arizona.
Correct, Your Honor.
And how long are you anticipating being in the custody of the Department of Corrections in the state of Arizona?
Serving a term of 10.5 years, and I have 10 months left to my sentence, sir.
So at a minimum,
10 months remaining.
10 months. How long have you been in custody? You said 10 years?
Yes, sir.
So when were you convicted in Arizona?
2018, I was convicted.
Okay. So can you tell me about your whereabouts between 2012 and 2018?
Following my arrest in North Dakota, I was extradited to Louisiana, where I reside.
You reside in Louisiana.
Correct.
And you were extradited from North Dakota to Louisiana?
Correct. About
Okay.
72 hours following my arrest, following my release in Barnes County.
So you were, I wasn't the judge in 2012, and I want to make sure I understand the timeline.
Okay.
So in your case, in the case that I have in front of me, you were summoned to court. And so what that tells me is you were released without arrest. Were you
Correct.
arrested for something else?
No, I was held for 3 days or so. And I was
Okay.
ROR.
And then you were released by
Yes,
Barnes County law enforcement.
correct.
And then were you released to the custody of Louisiana, or were you released on your own and then you were picked up and extradited?
Correct. I was released on my own, and about 72 hours following that, I was picked up by Louisiana, extradited back to Louisiana.
So when you're using that word, it means something special, and I want to make sure we're talking about the same thing. So you were released from jail in Barnes County.
Correct.
And so then you were released, and you're saying you were arrested again in North Dakota and held until Louisiana picked you up?
No, Louisiana bounty hunters came. They were alerted from my arrest in Barnes County, and they appeared at my doorstep about 72 hours after my arrest, after my release, and brought me back to Louisiana.
And so you say a bounty hunter picked you up.
Correct.
Was that person law enforcement?
The judge is just so into this story right now. He's like, a bounty hunter? Almost this entire hearing is a Princess Bride moment for the judge. Because the guy keeps using words, and it's that classic scene of, you keep using that word. I don't think you know what it means. Yeah, over and over and over again.
No, they were bounty hunters, private bounty hunters.
Okay. And so when you use the word extradite or extradition, what that means to me is a very formal process that involves a fugitive from justice case being raised in North Dakota. And you're saying that didn't happen. Some bounty hunters just came and said, come with us, we're taking you back to Louisiana.
Correct.
Okay. So you weren't formally extradited to Louisiana. Bounty hunters just came and took you.
Correct.
And you went with them.
Correct.
Okay. And so then you go back to Louisiana in 2012, sometime probably in August of 2012. And then what? How long were you in Louisiana?
Well, Well, from that time on, I was in Louisiana up until 2018. I was in the custody of Louisiana for about 18 months and then released.
So you would have been in custody in Louisiana between approximately August of 2012 until, give or take, December 2013.
Roughly, sir.
And during that time, the warrant in this case was issued August 23, 2012, right?
Sounds about right.
Okay. Did you take any steps because you knew that there was a pending North Dakota case?
I did not.
Steps to inform North Dakota that you were in custody in Louisiana?
No, sir. I did not.
Why not?
I had a lot going on. If to be honest, it was just I was just dealing with one thing as they came. And once I was released from Louisiana, I was just trying to put my life back together. And honestly, I never thought I'd be able to get back up there. I had too much going on. And I was being irresponsible, Your Honor.
Mr. Ryan, were you aware that a warrant had been issued in North
No.
Dakota?
No, sir.
All
But
right.
I assumed there would be. I
You
was never
assumed,
formally notified.
you assumed, but you weren't sure.
Correct.
So then at the end of December-ish 2013, beginning of 2014, somewhere in there, after your release from Louisiana, then what?
Then I was working in Louisiana, met a woman, had my first child, and just went about my life, honestly.
And so, sir, did you have a driver's license in Louisiana?
No, I did not.
Did you in 2013, 2014, 2015, 2016 through 2018?
No, sir.
Did you pay taxes in Louisiana?
Yes, sir.
And when you paid taxes, did you inform the state of Louisiana of your residential address?
Yes, sir.
Did you inform the federal government of your residential address when you paid taxes?
I did, sir.
Okay. Did you take any other steps to live open and notoriously in the state of Louisiana at your residence?
I've had leases, car payments. Yeah, I've worked freely and openly, worked and lived, child care, all the bills that come with a life, you know.
And so, sir, you said that you had a child while you were in Louisiana.
Correct.
Were you listed as the father of the child on the birth certificate in Louisiana?
Correct, Your Honor.
And was that birth certificate maintained by the Department of Vital Statistics or its equivalent in the state of Louisiana?
Yes, sir.
And was that on file with the state of Louisiana, sir?
I believe it should be. Yes, sir. I see why, no reason not for it to be.
Was your residential address included on that birth certificate?
Yes, sir.
All right. And now we're beginning at 2014, end of 2013, and somehow there's a gap there until 2018, and at which time you were convicted in Arizona. Tell me about
Correct.
that.
That gap is just working. I'm a commercial diver by trade. I travel a lot. I work in the Gulf of Mexico, deep sea diving, oil rigs, underwater welding, and construction. And it brings me around on the off season. I work inland throughout different states, and that's what partly brought me to North Dakota originally. I worked for a drilling firm, Falk Drilling, and yeah, I traveled a lot throughout those years, providing for my family. Also doing state dam work in the state of Arizona, back and forth, and those years are filled with work, honestly.
What did you use for your identification when you sought employment?
State identification card, sir.
Okay, so when a person applies for a job, they have to fill out an I-9 form. And the I-9 form has a requirement that the person provide either one type or class 1 or class A type identification. So a passport, a military ID, something like that. Or in the alternative, they have to provide at least 2 other forms of identification to work lawfully in the United States, like a government-issued driver's license plus a social security card. Do you understand what I'm talking about?
Yes, I do, Your Honor. And I provided my social security card with my identification card. And I also received a TWIC card, a transient workers identification card, which I had to renew every 2 years through the federal government to work on waterfronts and secure premises like dams and nuclear power plants where I normally work.
And that identification comes from the federal government.
Correct. It's a TWIC card, transient workers identification card.
All right. And then so in 2018, you find yourself in Arizona and you are accused of committing a crime in Arizona?
Yes, correct, Your Honor.
And what crime is that, sir?
I was charged with manslaughter, Your Honor.
And you were arrested and ultimately convicted of manslaughter in Arizona?
Correct.
Okay. And you didn't enter the Department of Rehabilitation or Corrections in Arizona under a false name, did you?
No, Your Honor.
It was your identification, your name, your full social security number, and your federal SS or SID number.
Correct, Your Honor.
When did you first become aware of the warrant in this case?
Meaning back in 12?
The warrant was issued in 2012. When did you first become aware of it?
I wasn't aware of it. I just wrote the courts because I'm coming to the end of my sentence and I wanted to be released back in and go and be productive and not have things hanging over my head, or if there was a fine or a fee or anything I had to take care of, I wanted to take care of it. That's why I reached out to the courts.
I understand when you reached out to the courts and why you reached out to the courts. My question, sir, is when were you first sure a warrant was issued in the state of North Dakota?
July of this year when I received a letter back from the court. That's when I was positive that there was a warrant.
So no one in the Arizona DOC told you there's a warrant?
No, Your Honor.
The warden or the director didn't notify you of an outstanding warrant under the Interstate Disposition of Detainers Act?
No, sir. And the last 3, I've worked my way down from higher levels down to a minimum yard the last 2 years. And I have an outside job as well. And they do warrant checks. I understand that I can't be on this yard with warrants, with open detainers.
All right. Sir, if you were held and I didn't quash the warrant and I said we're going to have a trial, what prejudice would you suffer if I were to say your speedy trial rights were not violated? You're looking off screen like you're confused, so let me ask the question maybe in a different way. Yeah. One of the factors the court is required to consider in assessing a speedy trial violation claim is the prejudice to the accused. And so what that means is here there is unquestionably a lengthy delay between the issuance of the warrant and you being brought to trial. There is a question about who caused that delay. There's a question about the extent to which you asserted your right to a speedy trial. Those are the 4 factors the court's required to consider. 1, how long is the delay? 2, who caused the delay? 3 is the extent to which the defendant demanded a speedy trial or asserted his right to a speedy trial. And 4, that's the question I'm asking you, is the prejudice to the accused that the delay caused. So tell me how this substantial delay hurts your case in your words or in your opinion.
Well, in my opinion, I would have had more time to gather information about my defense. I would not be vulnerable to possibly experiencing more prison time. It might have been run concurrent.
It has made it incredibly inconvenient for me, Your Honor. the argument that I would have had more time to prepare, that kind of falls flat on its face when the accusation is that they didn't bring it to trial in a timely manner. You've had more time to prepare than you should have, in fact.
I might not be in the minimum yard I'm in because I'd be in a higher custody due to the fact that there'd be warrants if I knew about them or anybody knew about them. If the Department of Corrections in Arizona knew about them, they, you know, it would change my situation or acted upon it. It would have taken away my ability to complete my degree, which I'm working on, because I'd be in a different unit without.
All of those are benefits you've received from them not bringing this case forward. I don't think you understood the question, sir. The question was, how were you negatively affected or prejudiced by them not bringing this forward? And you're telling him all the good things that have happened. You were able to go to school. You were in a less restrictive yard. Sir.
The same facilities. Multiple reasons why, sir. Had I been notified earlier, I would have addressed the court earlier.
Mr. Ryan, the charging document in this case, the information doesn't list any witnesses for the state. Would you have the ability to speak with witnesses from the PetroServe gas station?
I surely would not, sir.
And how would not being able to speak with witnesses affect your case?
Well, it would affect my case drastically. I would have it would take away my defense. A witness could possibly dispute the facts or the accusations brought upon me.
All right. Is there anything else that you want to tell me under oath, sir? Here's your opportunity to give me that narrative statement if you want. I'm going to just let you tell me what you want me to know. But I want you to understand that what you say is subject to cross-examination from the state. But here's your opportunity to tell me what you want.
No, that'll be all, Your Honor.
All right. Mr. Jackson, do you have questions?
Just briefly, Your Honor. You earlier indicated that you assumed that there was likely a warrant out here in North Dakota. Is that correct?
Correct.
Did you make any inquiry as to whether there was actually a warrant?
No, sir.
Since you were brought back to Louisiana, have you ever been back in the state of North Dakota?
No, sir.
You said you traveled to a lot of different states for work. Is that correct?
That's correct, sir.
How many different states?
10 to 15 annually.
Over the length of how many years would you?
15 years, sir. And if I may, going through the application process for my TWIC card and nothing ever being flagged, I honestly thought that it was dropped, that I had no issue. That's why I didn't give it too much thought afterwards.
Have you ever requested discovery?
No, sir.
Do you think discovery would be required to help you with your defense?
Yes, sir.
If you received discovery, would you be able to contact individuals that may be able to help you with your case?
I don't believe so, sir. Not at this time.
Is that because you're incarcerated?
Yes, sir.
Do you have contact with anybody outside of the facility you're currently located in?
No, it's just my children, sir. They're minors.
No further questions, Your Honor.
Mr. Ryan, the state asked you a number of questions. And ordinarily, if you had an attorney, the attorney would have an opportunity to rebut or redirect you and ask you additional questions. Again, because you don't have an attorney with you, I'm going to give you that opportunity, sir. Is there anything else that you want to tell me in response to the state's questioning?
No, sir. I just wanted to address that. Like I said, that the process to receive that TWIC card and that identification card, it brought me ease that I had no warrants or detainers.
All right. Mr. Ryan, any other witnesses, evidence, or testimony that you wish to present?
No, sir.
So you rest?
I rest, sir.
Mr. Jackson, any witnesses, evidence, or testimony?
No, Your Honor.
Mr. Ryan, any closing argument on your motion?
No, Your Honor.
Mr. Jackson, any closing argument on the motion?
Just briefly, Your Honor, ask the court to take into consideration the state's previously filed response. In addition, Your Honor, the state recognizes that the length of delay here is greater than a year, so Your Honor has to use the balancing test. The state would submit that the defendant was the cause of this delay. He believed he may have a warrant, but never actually attempted to find that out for a number of years.
Whose duty is that? Is it the duty of the defendant to bring themselves to trial, or is it the duty of the state to attempt to serve the warrant? And if it's the duty of the state to attempt to bring the defendant to justice, what efforts did you put in the record concerning the state's efforts to serve the warrant? Especially considering he was in custody in Louisiana and he's been in custody in Arizona for the previous 10 years. So he's been in custody for a total of almost 12 years out of the delay. Why isn't it the state's responsibility to identify a person that's in custody during those 12 years and to serve the warrant at some point throughout that process?
Your Honor, I understand what the court is saying. Even if the defendant had been served during those years, and I understand that this may not be a sufficient answer for Your Honor, but this would be a non-extraditable case. So even if he was located in a different state, and I understand, Your Honor, that that might not be sufficient for the court. But
it's a misdemeanor. So even without extradition, we could have taken care of it by Rule 43. We could have taken care of it by Zoom. We could have taken care of it in any number of ways if the warrant was served, right?
yes, Your Honor.
Okay. You can continue with your argument.
Thank you, Your Honor. Your Honor, additionally, the defendant didn't assert his right to speedy trial until very recently, as listed in the state's response. For prejudice to the defendant, Your Honor, he indicated some prejudice that he may be having currently based on his incarceration status. However, I didn't hear anything about how he would be prejudiced besides maybe not being able to talk to witnesses, potential state's witnesses in the matter here in Barnes County. However, he has not requested discovery to ascertain that.
So the charging document in this case is facially deficient in that it does not identify witnesses as required by Rule 7, correct?
Yes, Your Honor, I did. After Your Honor brought that up just now, I did pull that document up, and I do see that the witnesses section is blank.
And are witnesses' memories of some event that occurred in 2012 likely to be more accurate or less accurate, considering it is now 2026?
Your Honor, I don't believe that their memory would get better. If anything, it would decrease.
Okay. And is it reasonable for the court to assume prejudice in circumstances where we're talking about 14 years between the case being charged and the conduct occurring, and when a trial may occur in 2026?
Yes, sir.
Does he have to prove actual prejudice in light of that extraordinary delay?
Your Honor, I am not certain whether he would have to prove actual prejudice, but it is his burden to establish under those 4 factors.
Under a City of Grand Forks v. Gale, the court can presume actual prejudice in certain cases, right?
Yes, Your Honor.
And in that case, he doesn't have to prove up that he is actually prejudiced. He merely has to allege it, right?
Correct, Your Honor.
Anything else, Mr. Jackson?
Nothing beyond the brief and what the state has already argued regarding the cause of delay. Thank you, Your Honor.
Mr. Ryan, anything else from your perspective?
No, Your Honor, I just thanks the court for their time, Mr. Jackson for his time, and his attention to this matter.
All right. Well, there are two cases that have been decided that I think are controlling in this matter. One is City of Grand Forks v. Gale, 2016 ND 58, 876 Northwest 2nd 701, and State v. Borland, 2021 ND 52, 956 Northwest 2nd 412. I'm going to talk about Gale first, then I'll talk about Borland. Both cases cite the seminal U.S. Supreme Court case, Barker versus Wingo, which created, or at least set forth, the federal standard for assessing speedy trial claims under the U.S. Constitution. Barker versus Wingo is at 407 U.S. 514, decided in 1972. The four-part test set forth in Barker versus Wingo are just what the court outlined. 1, the length of the delay. 2, the reason for the delay. 3, the accused assertion of the right to a speedy trial. And 4, the prejudice to the accused. No single factor of the test is controlling, and the court must weigh all of the factors. In Gale, the facts of that case involve a DUI prosecution. The facts arising or creating the DUI or resulting in the DUI citation in 1995, the defendant ultimately failed to appear at a hearing there, and the court issued a warrant in 1995. There was a delay of 20 years in that case. No action was taken until March of 2015, when the defendant filed a motion to basically quash the warrant. The City of Grand Forks in that case filed an amended information. Then Gale filed a motion to dismiss, arguing that a speedy trial right, or his speedy trial right, had been violated. Ultimately, the trial court found that that was not a speedy trial violation and held the trial. Gale was convicted. In that case, Gale argued that this substantial delay of 20 years limited his ability to contact witnesses, for him to have a meaningful defense. The witnesses did not recall much of what happened. They relied on the written reports from 1995. The city claimed it could not find Gale because he'd moved to Colorado soon after he failed to appear, and that they had no reason to know Gale's whereabouts, that he caused the delay, and therefore there was no speedy trial violation. Gale testified that he was unaware of the pending case and that a bench warrant had been issued because his attorney had told him that the case had been closed and that his bond had been used to pay the associated fines. Gale was made aware, according to him, of the open case when a background check, when he tried to find a new job, revealed the warrant. The court found Gale's testimony incredible and reasoned that Gale likely knew that the case was pending but chose not to do anything about it. In that case, the court analyzed the Sixth Amendment right to a trial, speedy trial, cited Barker versus Wingo and State v. Moran, outlined the 4 factors the court's required to consider. Court must first, on the first factor, determine the length of the delay in defining that threshold as a threshold inquiry. The delay must be long enough to be presumptively prejudicial. If the delay is longer than what is usually allowed for criminal prosecutions, the delay is presumptively prejudicial, and the court must complete the rest of its analysis. A presumptively prejudicial delay alone is not a speedy trial violation. The other factors still have to be weighed. Generally, the court has found that 1 year is sufficiently long enough to trigger that presumptively prejudicial basis. Here, the delay is from 2012 until 2026. That delay is far more than a year. It is presumptively prejudicial. That triggers the rest of the constitutional analysis. In Gale, the Supreme Court described a 13-month delay in State v. Little Wind as considerable. A 17-month delay was, quote, significant in State v. Runk, and said that the United States Supreme Court described an 8.5-year delay as, quote, extraordinary in Doggett versus United States 505 U.S. 647, decided in 1992. Here, the delay in this case of 14 years is longer than what the U.S. Supreme Court described as extraordinary in Doggett. That factor weighs in favor of finding a speedy trial violation. That length of delay is significant, it is considerable, and it is, in this case, extraordinary. The second factor is the reason for the delay. In Barker versus Wingo, the U.S. Supreme Court says a defendant has no duty to bring himself to trial. The state has that duty. That's from Barker 407 U.S. at 527. However, if the defendant causes the delay, the factor weighs against him. That's what the North Dakota Supreme Court said, State v. Moran, 2006 ND 62, paragraph 10. The reason for the delay is closely related to the last factor, or prejudice to the defendant. The defendant's burden depends on the government's diligence in bringing the case forward. In United States versus Cardona, cited in Gale, Cardona, in that case, the Fifth Circuit is quoted as, quote, if the government diligently pursues a defendant from indictment to arrest, a speedy trial claim will always fail without a showing of actual prejudice. On the other hand, if the government intentionally held back its prosecution to gain some impermissible advantage at trial, that fact weighs heavily against the government. The middle ground between diligent prosecution and bad faith delay is government negligence in bringing the accused to trial. In State v. Moran, the North Dakota Supreme Court discussed that negligent delay as follows. When the state diligently pursues the defendant must prove actual prejudice. When the state intentionally delays prosecution because of a bad faith motive, the prejudice is presumed. When the state has been negligent by not diligently pursuing the defendant, the weight of the other factors and the length of the delay controls whether prejudice must be actual or may be presumed. Like in Gale, the state in this case argues it's Mr. Ryan's fault that there was a 14-year delay because he left the state of North Dakota, essentially that he absconded. Generally, the law is if a person absconds the jurisdiction, that period of delay is excluded and not considered for speedy trial purposes. Here, the court finds credible Mr. Ryan's assertion that he was approached by private bounty hunters from the state of Louisiana, and they removed him from custody, or removed him from the state of North Dakota, took him into custody, and returned him to Louisiana. That ultimately is not a willful action on behalf of Mr. Ryan, although it does pose the court some concern that there are private bounty hunters operating in Barnes County without law enforcement apparently having any knowledge of those private bounty hunters snatching and grabbing people from Barnes County and taking them out of state. The court finds that once he was taken into custody, some other state's interest in Mr. Ryan, and by interest I mean penological interest in Mr. Ryan, makes his absence from the state involuntary and means that he did not cause the delay. The court doesn't attribute that factor against Mr. Ryan. The court finds credible Mr. Ryan's belief and testimony that he believed the matter was taken care of or resolved. He was unaware of the warrant, although he suspected it. The court finds credible Mr. Ryan's testimony that he suspected but did not know of the warrant. The court asked that question of Mr. Ryan in several ways. Mr. Ryan asserted that he was unaware of the warrant actually existing until the court issued its order. And the court finds that Mr. Ryan's initial filing asked about quashing a warrant or the citations and doesn't appear as though he's ever really appeared in court. And because he's never appeared in court and he was unable to be located for the service of the summons, he was unable to be located for the service of the warrant, at least that's the court's understanding from the record, and that's the only evidence before it. The court finds credible Mr. Ryan's testimony that he was unaware of the warrant, and to date, the warrant has not actually been served on Mr. Ryan. He is aware of it because the court informed him of it. And because he was unaware of the warrant, the court finds that factor weighs in favor of a speedy trial violation. The court notes that it is very similar to the City of Grand Forks v. Gale fact pattern, substantial delay. This North Dakota Supreme Court discussed the district court's analysis in that case, citing in paragraph 13, much of the district court's analysis under the factor focused on whether Gale was actually aware of the pending case and warrant rather than allocating culpability for the delay between the parties. The analysis concerning Gale's knowledge of the facts or knowledge of the case and timeframe in which he decided to take action is more appropriate under the next factor, the accused assertion of the right. Awareness of pending charges is different from causing pretrial delay. While Gale may have been aware of the pending case and warrant, quote, it is axiomatic that a defendant has no duty to bring himself to trial, end quote. And there's a string citation involving Wyoming, Barker, the U.S. Supreme Court's decision, and a Minnesota Court of Appeals decision from 2009. I am not finding that Mr. Ryan intentionally avoided prosecution. The court finds again that upon his release from Barnes County's custody, or finds credible his assertion that he was taken essentially involuntarily to another state. And after his lengthy incarceration in the state of Louisiana, no warrant had been served and he assumed that it had been taken care of. The court also finds concern that the government didn't produce any evidence that it actively tried to serve the warrant in light of State v. Moran 2006 ND 62, well-established law. The court finds that the government was negligent by not diligently pursuing the accused. That puts the burden on the state to establish that it diligently pursued the warrant or actively attempted to pursue the warrant. The state presented no evidence that it actively pursued the warrant. The court elicited testimony from Mr. Ryan concerning his whereabouts and factors that should have alerted the government as to Mr. Ryan's whereabouts. That turns to the third factor, whether or not the defendant asserted his right to a speedy trial. When a defendant does not know of the charge against him, not asserting the right until after arrest cannot weigh against him. That comes from State v. Moran, paragraph 15, and discussed again in Gale. Again, the city in Gale argued that it was Gale's fault for not asserting his right because he should have been aware of the case. Gale claimed he was unaware that the case was still pending. That seems very similar to the fact situation here. Again, Mr. Ryan was charged with a crime. He had law enforcement contact. He asserts that he was held in custody and then released 3 days later. There's nothing in the record indicating he was arrested. Instead, this was a summons case. And so to me, a person who's summoned is usually cited and released and not taken into custody. Mr. Ryan asserted that he was actually taken into custody and then held for 3 days, which is problematic for other reasons, and then released on his recognizance. But there is no bail order that was put in the file. There is no finding of probable cause, so it raises issues under the Gerstein versus Pugh and McLaughlin, County of Riverside versus McLaughlin cases 2, and State v. Belinsky in North Dakota concerning his initial detention and his ultimate release. The summons was never served on him, so it's presumably true that the information was never served on him either. While he may have suspected the case was outstanding, the court does not find that Mr. Ryan had actual knowledge of it, and therefore As stated again, State v. Moran, failure to assert the right to a speedy trial cannot be weighed against him, but he's not aware of the actual case. And so I don't attribute that against Mr. Ryan in this matter.
Wow. Do you agree, Billy? It sounds like Mr. Ryan is going to get this dismissed because the burden fell on the state and the state did not act.
Turning to the fourth factor. The fourth factor is prejudice to the defendant. The United States Supreme Court has instructed the factor to be weighed in light of the interest the speedy trial right was meant to protect. 1, to prevent oppressive pretrial incarceration. 2, to minimize anxiety and concern of the accused. And 3, to limit the possibility that a defense will be impaired. Here, the court finds the first two purposes are inapplicable. Mr. Ryan was not oppressively incarcerated pretrial. The court does not find that Mr. Ryan had much anxiety or concern in light of his other incarceration on serious matters. I'm presuming the Louisiana matter is a felony, and I'm certain the Arizona matter is a felony. Mr. Ryan had other matters, and so I don't believe any anxiety or concern to the accused is an issue, and I find those factors inapplicable, or those rights applicable in this case. I do, however, find that the substantial, extraordinary period of delay limits the possibility that Mr. Ryan's defenses might have been impaired. This is coupled with the fact that the information is deficient on its face. He couldn't have spoken with witnesses because the witnesses weren't identified, even if he had been served with the information. To date, 14 years later, he doesn't have discovery from the state's questioning. The court finds it unlikely that digital or video evidence would have been preserved. The court finds it likely that witnesses will have moved on from a gas station type employment, making it difficult to track those witnesses down at this point. The North Dakota Supreme Court discussed presuming prejudice in Gale, citing Doggett, U.S. v. Doggett, 505 U.S. 655, concerning presumptive delay. Our Supreme Court quoted the U.S. Supreme Court in Doggett as, quote, Barker explicitly recognized that impairment of one's defense is the most difficult form of speedy trial prejudice to prove, because time's erosion of exculpatory evidence and testimony can rarely be shown. And through time, and though time can tilt the case against either side, one cannot generally be sure of which of them it has prejudiced more severely. Thus, we generally have to recognize that excessive delay presumptively compromises the reliability of a trial in ways that neither party can prove, or for that matter, identify. While such presumptive prejudice cannot alone carry a Sixth Amendment claim without regard to the other Barker criteria, it is part of the mix of relevant facts, and its importance increases with the length of the delay. Here, the court asked the state questions about witness memory, the likelihood of our availability of witnesses. The state acknowledged that their memories would not be getting better. And again, the length of time here that we're talking about is extraordinary. So turning to the other case that I mentioned, State v. Borland was a 2021 case that reached a different conclusion. In Borland, Mr. Borland was convicted in a jury trial of criminal vehicular homicide. This was his third jury trial. He argued double jeopardy barred his retrial and that he was denied the right to a speedy trial. He argued that the homicide occurred on October 17, 2017, and he was not ultimately tried until February of 2020, so 3 years. and he argued that his speedy trial rights were violated. Important to note, in Borland, it was the third trial. Mr. Borland remained incarcerated for the majority of that, if not all of it. There was not this substantial delay, although there was a lengthier delay than normal between the conduct and the third trial. There were efforts to pursue the case multiple times involving 2 previous trials. There was not the allegation that Mr. Borland left North Dakota or that he caused the delay by absconding from the jurisdiction. The first delay in Borland's case was the result of a state's request for a continuance because of accommodating witnesses. Borland did not object to the continuance. Continuance was granted. There was another delay because the state moved to continue without providing justification for the request. Again, Borland did not continue or object to the continuance. The court found that continuances in those cases were not caused by some improper purpose, and there were valid reasons for the delay. And the state was not responsible for juror misconduct occurring during the first trial, or the jury's inability to reach a verdict during the second trial. And the state's requested continuances indicated no intentional or negligent delay on behalf of the state. With respect to Borland's assertion of his speedy trial right, he did not assert his right to a speedy trial in 2017. He didn't raise the speedy trial issue until the end of 2019, so almost 2 years later, less than 2 months before the third trial was set to begin. They weighed that factor against finding a speedy trial violation. And lastly, the difference between this case and that case was requirement that in that case he prove actual prejudice, and in Gale, the court presuming prejudice existed because of the 20-year delay. Here, the court finds this case is more comparable and akin to Gale than it is Borland, for the reasons the court explained. Court finds that Mr. Ryan's speedy trial rights have been violated under the North Dakota United States Constitution. The court dismisses the charge, the reasons it stated on the record. So the court will prepare a brief order. It's simply going to say, for the reasons stated on the record, the charge is dismissed. The warrant will be quashed as a result. Anything else for the state?
No, Your Honor.
Anything else, Mr. Ryan?
No, Your Honor.
With that, we're adjourned. Have a good day.
Thank you, sir.
Wow. He won. The pro se inmate won. We don't see that often. So I'm a little baffled, a little shocked. Because for reasonings of appeal purposes, he has to lay down every reason why he came to that conclusion. Because if the state were to appeal it, then the appeal judges would go just solely on what was placed on the record already. And if you don't place it on the record, it doesn't exist. That's why. It was. And in fact, the judge showed 2 opposing Supreme Court decisions and then explained why he leaned more towards one than the other. So it could have gone either way. The judge presented case law that supported both decisions, but ultimately determined that the case was more closely related to the one that allowed for it to be dismissed. Oh, evening Judge McNamara is going on. Nothing exciting ever happens in that court. I should really turn the notification off because they keep a pretty tight, they run a pretty tight ship over in that docket. I do too. I learn a lot from it. But I like learning. Billy's moody. And he keeps, last night, he demanded cuddles. He took Snitch's spot. He crawled up on my chest. And then at one point he slid off of my chest. And he just landed in my arms. So I just continued to cuddle him in my arms. And he got restless and he got up and he climbed back on my chest and demanded more pets. I think he got overstimulated at one point because he slid back off of my chest again and demanded that I pet him. And then when I started to pet him, he grabbed onto my arm and did the bunny kick on the back of it. And oh man, it hurt so much. I was not thrilled with it. But he's been moody. He's been very moody. Or he was trying to suck the soul from my mouth, like they say in those books. All right, you guys. You know how much I appreciate all of you and how grateful I am that you guys chose to spend your afternoon with me. I love you guys. I do not think I will be on later. This was today's stream. Thank you. Yeah, those were good cases. The beginning ones especially. Oh my goodness. I was excited when I saw them. I was so happy to share them with you guys. So I'm not sure if I will be on tomorrow because remember I said that I had hired someone to come help me with packing up my daughter's room. They were supposed to come today, but because of the heat, they were not able to make it, so they are coming tomorrow. And so I don't know how physically okay I'm going to be able to stream, but we will see. It's actually more, I won't be able to find content and edit it and prepare it for the evening because it's a lot of work. So it might be, yeah, they're selectively cuddly. It's all when they decide they want to. Absolutely. Oh man, when he told me, my heart just sank. I was like, thank God he came to see me when he did, you know? He goes home and has a stroke like right away. Well, what? I promise you guys, it wasn't me. I didn't do it. It's gonna be a hot week. Oh, I know, but I can't get up and walk around during body cams. And when I'm in a lot of pain, I have to move and stretch. And I really don't want you guys to have to see that because it's sort of embarrassing. And with body cams, I'm not supposed to leave at all. at all. So I try to follow the rules. With the cases that I edit, I'm able to get up and move around a bit. I know he has family, Charlie. I don't know how close they are. But as far as I know, they're close, like emotionally. Like they're very, very much a loving family. But I don't know distance-wise if they're close enough to help him out like that or not. I don't know. You'll have to ask him about that. I know, Edie Weedy, stupid rules. Jerry, you're just gonna have to entertain yourself. I hear you're good at that. You've got years of practice. Maybe watch a movie, Jerry. Maybe Jerry will entertain the masses on Discord. Right, it's since it's in my lower back, the stretching is in my legs that I have to do. I have to do piriformis stretches, or it feels like I have a baseball in my butt cheek. And then I don't know, I gotta prop my leg up and do all kinds of like Pilates yoga looking stuff. I don't know. It's weird. And it's not pretty. It's not flattering. By any means, it's not flattering. So I have to do it off camera. And sometimes I just walk to the end of the house and walk back, and that's as much as I can take. So it's just a mess. But I do have to get my daughter's room packed up so that I can submit the insurance claim for my roof. I want to see that Acme movie that got shared, but it's not out yet. It got shared in Discord. Charlie. I bet they understood. You were going through a lot, buddy. Jerry wouldn't care. He would actually prefer. Jerry, oh duh, did I just say at Jerry? I did. Wow. The Acme one that was shown, it was shared in Discord in the Insomniac chat, and then you DM'd me and you said it doesn't come out till like August 26th or something like that. That one where Wile E. Coyote sues Acme. That's the one that I want to watch. I still have to watch the other one that I told you I wanted to watch that you didn't like. See, I don't watch movies. I really don't. I've told you all this before. I don't watch movies. I don't even watch TV. My TV hasn't been turned on in over a year. The last time it was used was when Homosexual played his games on it. I have no interest in watching my TV. I do everything on my phone and computer. If I'm watching something, it's with the intention of will I stream this? I know there are. I know there are, Charlie. Yes, there are so many of them. They are fantastic, and millions of dollars gets put into them, and you know, I think that's great. I just use my time in different ways, because if I don't find stuff to stream, then I don't get to stream. All right, guys. Be safe, be well, sleep sweet, and much love.